Good afternoon, ladies and gentlemen. We should start immediately. We have a slight delay. So I would like to introduce our first speaker, Juan Carlos, not the Bourbon, but Gonzalez.
No.
He is an associate with Latham Watkins, a well-known competition law firm, and he also did a traineeship at the European Commission, something which I think he shares with many among us. Without further ado, I would like to give you the floor, except to make a comment on the arrangement for this session. I propose that after every presentation, we have one or two, maybe, questions just for clarification. And that means that your questions should be really short, not long expositions, just ask what the speaker meant. And then towards the end, we'll wrap everything up and we have general questions. Is that okay with you? Okay, then we start. Juan, you have the floor.
I will discuss 5 different topics. So I will provide a very brief introduction to state aid and taxation. Then I will discuss very briefly the basic principles of state aid, which are common ground and common knowledge. And then I will move on to discuss the 1998 notice on direct business taxation. And then I will move on to discuss the notice on the notion of state aid, the current one, which was published a few weeks ago. And finally, I will cover the hot topic in the area of taxation, which is right now the notion of selectivity. So as some background information, I think that, well, currently nobody doubts that taxation is subject to stated rules and that the exercise of member state sovereignty is subject to the control of stated rules and also of the treaties in general. So over the last years, we've seen the competition opening different in-depth investigations. For example, we have the tax rulings, but we have also other initiatives. For example, we have the famous Spanish financial goodwill saga. We have the Spanish tax list in the case of shipyards. So there are many different things going on in direct and indirect taxation. However, stated control, in the case of taxation, is not new. Since the early 70s, in the case Italy against the Commission, the ECJ already held at that time that taxation was subject to stated control. But how important is taxation in the context of state aid? Well, the Commission, according to the last scoreboard of 2014, it has calculated that more or less 30% of all state provided is provided in the form of tax exemption. So it's a significant amount of state aid provided in that form. So, well, here is a very basic slide, just to remind that for a measure to qualify as state aid, we have 4 different requirements. We need an intervention by the state or through state resources. We need a selective advantage granted by the state, a potential distortion of competition, and the measure must has some effect on trade between member states. But when we talk about the notion of state aid in the context of taxation, we need to bear in mind that there are 2 special requirements which are, let's say, controversial in this area. The first one is the notion of state resources, and the second one, which is more important and more controversial right now, is the notion of selectivity. So when we talk about state resources, we know that it can be a positive measure like a direct grant, but it can also cover other measures in which an authority, a public authority, is waiving revenues. So we can talk about negative measures, so a reduction in the tax base, tax credits, etc. Then we know that another requirement is that the member state needs to provide an economic advantage, and it must be selective. So when we talk about selectivity, we know that the measure must favor certain undertakings or the production of certain goods. Even though this quotation seems to be very, very straightforward, then this is not Pacific right now. So the problem that we have in taxation is to establish the boundaries on the one hand on the member state sovereignty, because we know that taxation is subject to unanimity according to the treaties, and on the other hand, well, the Commission has the power to control state aid granted by member states. So this is a difficult equilibrium that, well, that they have to balance. So the 1998 notice on direct business taxation was the first time that the Commission decided to publish something, some guidance in this area. But we are talking only about direct business taxation. Well, it's clear that member states use the fiscal system in a way that they can accommodate more or less their economic structure, which is specific to every member state, and also they have different economic objectives. And what is interesting to see here in this notice is that if we read it carefully, we see that there is a section dedicated to general measures and state aid. So it seems that in some cases, the Commission seems to say that there are certain measures that shouldn't fall under the scope of state aid rules. So for example, a reduction in the taxation of labor, the Commission considered at that time that is of course a general measure, and if it favors labor-intensive industries, it doesn't matter. Now, it seems it has changed a little bit, at least the analysis. So, a few weeks ago, I think that it was 3 weeks ago, something like that, the European Commission published a new notice on the notion of state aid. The first draft was published in 2014, and now they have decided to publish, well, the complete notice. And, well, in the case of taxation, it replaces the 1998 notice on direct business taxation. And when it discusses material selectivity, it explains that it's normally easy to identify selectivity in ad hoc measures. That's normal. That's very easy, very straightforward. So the problem that we have about following the context of taxation is when we are discussing broader measures applicable to many undertakings, which they must fulfill certain criteria. In this type of cases, we normally apply what is known as the three-step approach. So we must have the reference system, then a derogation, and then member states, well, the measure is considered to be prima facie selective, and then the member state can still justify that the measure is not a state aid because it's part of the general scheme of part of the system. So maybe the member state has some scope, but it bears the burden of proof. However, the notice also discusses the Gibraltar case, and it tries to reconcile, on the one hand, the Gibraltar case, and on the other hand, the three-step approach, because since 1998, there's been some legal developments, and the Gibraltar case is quite telling and quite striking, because in that case, we had a reference system that was designed in a way to favor offshore companies. So the Commission didn't follow a three-step approach in which there was a reference system, a derogation, and then member states tried to justify it. But the reference system as such was already biased to favor certain undertakings, in this case, offshore companies. So the notice tried to reconcile both areas, and, well, we can discuss to what extent it does it. And as I was explaining previously, when we discuss the notion of material selectivity, not regional selectivity, the Commission normally follows a three-step approach. So first of all, the Commission analyzes the reference system. Once this is identified, the Commission will have to establish that there is a derogation from the reference system. And if this is the case, we have a prima facie selective measure. Then the member state has the possibility to justify the measure by the nature of the general scheme of the system. So in practice, what happens? In practice, every derogation to a reference system is considered to be a state aid. And the member state bears the burden of proof. And the European Commission is the one that decides whether the justification is compatible or is accepted or not. So the problem is that right now, most of the measures and most of the derogations would constitute a state aid. So the powers of the Commission in this area are really, really, really significant. So this is just a way to illustrate where the debate it is right now. So we have the Spanish financial goodwill saga, which is about the amortization of the financial goodwill, in which, well, there was a provision in the Spanish income tax code which provided that the Spanish companies could amortize the financial goodwill resulting from the acquisition of shareholdings of more than 5% in foreign companies for a period of 20 years. The Commission found that this measure was a state aid and incompatible with the internal market because companies didn't have this possibility in relation to acquisition of shareholdings in national companies, in Spanish companies. And we have three different decisions. The first two, one relates to intra-EU acquisitions, and the second one relates to foreign acquisitions in third countries. In both cases, it found that it was state aid and incompatible. And the third one, there was a third decision, which was, I think, quite striking among the community or among people involved in this matter. It was that the Commission published the decision 3 weeks before the General Court released the judgments on the first two decisions in 2014, the famous Autoril against Commission and Banco Santander against Commission. What is interesting of these judgments is that the General Court said that we need to conduct the three-step approach, so we need to identify the reference system, also the derogation, but the issue is that the Commission should have identified a category of undertakings which were favored by the measure. And the problem is that, according to the General Court, this group of category of undertakings having some common features wasn't identified by the Commission. So every company could buy shareholdings in foreign companies in other countries. So according to the General Court, there was a problem in the legal reasoning of the European Commission. By the way, in this area, there was an oral hearing that took place the 31st of May, because the Commission appealed the first two decisions and, well, the first two judgments of the General Court, and I was lucky that I attended the oral hearing, and there was a very lively discussion about selectivity. The whole issue was about selectivity. The point is that, and the main point of discussion, and the judge rapporteur asked many questions about whether Gibraltar was applicable to this case. And she seemed to have some doubts about whether the Gibraltar judgment was applicable to these cases, because also the Gibraltar judgment talks about the need to identify undertakings having some common features in order to establish that there is a selective measure. So in this slide, what I try to show again is that this issue of selectivity is right now everywhere. And in this case, this is a reference for a preliminary ruling. And in this case, it was referred by the Austrian court to the ECJ. And it's a very similar case to the Spanish financial goodwill, but it's the other way around. Because in this case, the measure allowed companies to amortize the acquisition of shareholdings at national level, whereas the acquisition of shareholdings by companies in third countries or EU countries, companies were not allowed to amortize the goodwill in the same way. So the Advocate General, I think that in this case it was Cocotte. She used this very similar reasoning to the financial goodwill matter when she discussed the issue of selectivity. According to her, it's not sufficient. We also need to identify the undertakings or a specific group of undertakings that are affected by the measure to conclude that the measure is selective. And yeah, it's a very similar reasoning. The problem in this case is that the ECJ released the judgment and the preliminary ruling and didn't discuss this matter because the court didn't find it that that was needed for the national court to have this opinion on this area. So we will need to wait and see the judgments of the ECJ on other matters, for example, on the financial goodwill matter, to see how the ECJ deals with this notion of selectivity in the context of taxation. So as final conclusions, I just want to mention that that the 2016 notice has tried to reconcile what I said before, the Gibraltar judgment with the general approach to the notion of selectivity. Also, selectivity only relates to differences within a given member state. When we are talking about differences between different member states, this is not for selectivity. We can discuss about other matters, about maybe harmonization of taxation or other things, but when we talk about selectivity, it's in the framework of the member state. Then, the Commission has to act if there's really a real fiscal advantage. But we need a coherent approach that provides legal certainty to member states and undertakings, because right now the notion of selectivity can be quite vague in some areas. So, for example, the financial goodwill matter. So maybe at some point, maybe there will be a recovery. So there's no legal certainty in these areas, and we should have more legal certainty. And it's for the ECJ to decide on this. So what I was saying before is that we will need to wait and see what the ECJ will say about it in the next months or years to see whether it concludes that selectivity is only a derogation or we also need additional requirements. So thank you very much.
I look at the audience. Is there any need for clarification?
¿Lo puedo acercar un poco?
Okay, yes.
Quick question. How does the concept of
So it's true that when we talk about de facto selectivity, it can happen, for example, if we have the financial goodwill matter, let's think it's not the case, or it's just hypothetical, that maybe some companies involved in the energy sector, let's say, are the ones who can apply that measure. So in that case, we have a de facto selectivity, and we are identifying the undertakings which can benefit from the measure. The point that I think that, for example, in this case of the financial goodwill matter, what they are discussing right now is that many different companies can benefit from this measure. There's not like a single sector, or there's no, we are not talking about only big companies, also small companies or SMEs can benefit of this from this measure. So concluding that there is a de facto selectivity, we'll have to wait and see how the ECJ decides on this.
My ask was by the nature of the three-step test. I mean, is this test compulsory as a method of analysis in the Commission or just indicative? Because I think that the Commission has merged to the concept of advantage and selectivity. And these three steps that not reflect the future of any one of them. The first one, establishing the benchmark, I think it belongs more to the field of advantage, which has also to research into the benefit and the derivation. And the second one, and of course this is objective. And the second one, the selectivity, it talks about the subjective aspects of the measure, and so that should be merged really with the third step, because a measure is not selective until it is not justified by the nature of the system. Thank you.
Can you keep it really short? Okay.
So, I mean, if I understood it correctly, I think that the idea would be that we should discuss about the selective advantage as a single concept instead of talking about two different steps. Well, I mean, what I can say is that, well, this is the current view of the European Commission, and I think that it's also based on the case law, in the sense that, well, we have an advantage. First they need to define whether there is an advantage, in the sense that there is a derogation from the tax system. So the point is that then is whether, I mean, right now, I think that there is some confusion between selectivity and the concept of selectivity and the notion of advantage. And I think that the future judgments will try to clarify it a little bit more, because the idea is that there should be a selective advantage, so two different things, like one complementing the other. But right now, it seems to me that there's some kind of confusion. I don't know if you have other views or if you agree, but...
Maybe this is a point we could come back at the end of the session. This was not sort of questions I intended. We have now our next presentation by Enrique Fonseca, who is a well-known tax lawyer, tax expert in Spain, and he is going to talk about the legal basis of the fiscal state aid regulation, and we're very anxious to hear what you have to tell us.
I want to thank Professor Villar for her kind leadership of the project and the tremendous work done, and also thanks to the rest of the San Pablo CEO University, and congratulations to all of you. Okay, as a summary of my paper, I'm going to submit to you some ideas about the legal basis of the current situation on the application of the state aid regime to the incentives on energy taxation and its possible evolution. I have to apologize in advance, because the reality is that most of my points have been already touched this morning, and I'm going to try to jump as much as possible. Well, there are three fundamental aspects that I would like to highlight: legislative powers, policies of the European Union, and positive law. On environmental matters, unanimity applies on all tax-related aspects. Although the ordinary legislative procedure applies for environmental and energy taxes, when regulations are essentially fiscal, unanimity is required, as it is required also in all harmonization process. Although it's not a legislative competence, the Council is also entitled to regulate the conditions of the application of Article 108, paragraph 3, and to establish the categories of state aid that can be excluded from the notification procedure. The Commission, in turn, is entitled to establish and develop general criteria limited to the exemptions considered by the Council and to control state aids, in both cases with wide discretion. Discretionality, but the procedure must never produce a result which is contrary to the specific provisions of the treaty. Article 191 of the treaty establishes the objectives and the principles of the environmental policy. Principles of caution, prevention, correction, and polluter pays are the cornerstones of the environmental policy. Polluter pays principle is a principle of higher order which must be taken into account in all regulations affecting the environment, and it is a principle of legal nature. However, polluter pays principle defines the general objectives of the European Union, which must be developed through decisions of the Council or jointly with Parliament. through legislative decisions. Talking about positive law, in my opinion, the Energy Taxation Directive is the source of most of the existing problems on the regulation and application of state aid regimes on energy taxes. The objectives of the directive, among others, were adopting minimum rates for the taxation on energy and energy products, reducing differences between member states, and their negative effects on the proper functioning of the internal market, to promote the environment, to influence the price of energy as an instrument of energy transport and environmental policies. The directive recognizes that certain tax reductions and exemptions have been included to avoid failure of the harmonization and the negative effects on international competitiveness, social damages, and other of environmental nature. After a long negotiation, there was a recognition of certain status quo that will influence the development of energy taxation and state aids in the European Union. The paradigmatic example of the mix of legal and political categories is the characterization as environmental measure of some exemptions or reductions included in the directive to obtain consensus, with the debatable legal argument that without them it would have not been possible to approve the directive, and the damage of the environment would be greater. The directive does not regulate an environmental tax, but impose what was considered a minimum necessary tax for the creation and the proper functioning of the internal market, taking also into account some aims of environmental nature, including some tax benefits for this purpose. The weight of the transactional component in the Energy Taxation Directive is great, and the directive has failed to create a genuine environmental tax. It has also prevented the evolution and modification of the directive in accordance with the evolution of the environmental policy and the rationalization of the energy market, acting as a standstill clause. The Commission has highlighted in its proposal for the revision of the Energy Taxation Directive its inadequacy to the needs of the environmental policy. There is a complex balance sheet between environmental policies and its principles of prevention and polluter pays and the rest of the Union's policies, which in fact implies absence of using tax tools for environmental purposes on energy at EU level, letting this possibility to the decision of the member states. Following the Energy Taxation Directive, state aids in the form of tax benefits on energy taxes have as unique specialty the authorization by the Council-enabled regulation in favor of the Commission to adjust the exemption from the obligation established in Article 108, paragraph 3 of the treaty, in particular notification, with respect to certain types of aid in favor of the protection of the environment. It is important to take into consideration that this is not a legislative act. The Commission guidelines has its own definition of environmental tax. The definition is far from the technical definition and far also from the approach of the environmental tax concept of the Court of Justice, as it is shown, for instance, in the case Transporte Jordi Basora. It's a wide definition that includes any tax with a specific tax base that has a clear negative effect on the environment, disregarding the structure of the tax and the possible action on the internalization of costs and the influence in the consumer activities. The General Block Exemption Regulation, in its preamble, includes the aids in form of tax reductions according to the Energy Taxation Directive as categories compatible with the internal market when can and indirectly benefit the environment. At the end of the day, the Article 44 of the General Block Exemption Regulation consider compatible with the internal market all the reductions contemplated in the Energy Taxation Directive, provided that certain conditions that has been analyzed in depth this morning are met. The general block extension regulation distinguishes between harmonized energy taxes, which are called environmental taxes, and non-harmonized energy taxes, so that the tax benefit granted on the first are declared compatible with the internal market and exempted from notification, provided that the minimum taxation of the directive applies and the beneficiaries are determined in a transparent and objective way, while the tax benefits granted on other taxes on energy non-harmonized shall be subject to the general rule of notification, even though in case of authentic environmental taxes. The General Court, in the case Republic of Austria, has confirmed guidelines criteria for harmonized and non-harmonized energy taxes. The final result of this regulation is that tax incentives included in the directive, although in many cases are granted with respect to activities or products especially harmful to the environment, are declared automatically compatible with the internal market, being subject to a double benefit, the tax benefit and the exclusion of the general notification regime of state aids. This double benefit is based on the assumption that harmonized taxes are environmental taxes, and also on the assumption that incentives in these harmonized taxes pursue environmental purposes because they were necessary to meet the unanimity in order to approve the energy taxation directive. However, not necessarily taxes configured in the directive are environmental taxes in a technical sense, nor many of these incentives referred to it in the directive have a purpose or an environmental justification. On the contrary, other energy taxes set by the member states, aside from the directive, can be authentic environmental taxes, including tax benefits that may be necessary for its implementation or may pursue exclusively environmental objectives and are subject to the general regime in the field of state aid, including notification. The case law of the European Court of Justice has not had, as in other matters, much belligerence to stimulate the amendment of the directive. The court has accepted the literal interpretation of the environmental tax concept as setting a clear distinction between harmonized and non-harmonized energy taxes, rejecting the application of analogy to these concepts and assuming the characterization as environmental taxes incentives of all tax reliefs included in the energy taxation directive, letting aside their real nature. Apparently, the court has assumed that the Council and the Commission discretionality allows them to assess whether or not a tax or its incentives are environmental for the purpose of the state aid regime. We're talking about harmonized taxes, maybe without taking into consideration the principles contained in Article 191 of the treaty and applying different criteria in relation with non-harmonized taxes. The regulation of the state aid and energy taxation directive results in a split of the concept of environmental taxation, which is used with a different meaning from the technical one, what damage coherence of the EU legal system and the proper use of a key concept in a critical matter as it is environmental protection. But there is not until now a complete analysis of the regulation and guidelines from the point of view of discretionality on these regulations and the requirements imposed by the definition of objectives and principles of the environmental policy in the treaty. And I think that the following questions remain open. Could the court change criteria? Could control of discretionary powers and the application of the principles of 191 article of the treaty give rise to a new approach to the issue? Equalization of harmonized energy taxes to environmental taxes could be deemed illegal and outside of the scope of discretionary powers, and in relation to tax benefits on harmonized energy taxes could happen the same. More equality could be required for incentives on harmonized and non-harmonized environmental energy taxes. Okay, and that's it.
What do you mean when you say that the general block exemption regulation is a non-legislative act? Do you mean it's not binding, or what does that mean?
No, the meaning of that expression is that the regulation of the Council in this matter is not legislative in the sense that it's an application of the authorization of Article 107 in relation with Article 108.3, and it's just a executive decision with a general application, but it's not a law in a proper sense.
In this session, we have the ladies last. So,
Absolutely fine with us.
yeah, it's fine with you. So without any further ado, I give you the floor.
Before starting, let me thank Marta, first of all, for sharing with me this speech today, but secondly, but more importantly, for organizing such conference and the research project in general. I also want to thank Professor Pistone and the IBFD for letting me in the project as such, and Javier, that I don't see anymore, and Monica for organizing the conference, and the THEO University in general, because it's always a pleasure to be here. It's already the second time, so I haven't seen Madrid so far, but I saw the university for sure. So today we are going to talk about the concept of environmental taxes in the energy sector, and in particular, we're going to focus on possible solutions taking into account technical issues in a state aid context. And let's see all together the agenda. So we decided to split this speech into four parts. I will deal with the first two, and then Marta will take over and deal with the last two parts of this presentation. We will see our research question, first of all. Then we will move to discuss the path of our project, which will be focused on the concept of environmental taxes and energy taxes, both from a general perspective and within state aid law. And then Marta will deal with the possible solutions to the problems that we found out, which are mainly three. And then in the last part, she will deal with the proposal that we have on this issue. So let's start from the first part, our research question. Well, today, Professor English said that the general block exemption regulation is too generous. We do agree with that, but we also think that if we take into account the legal concept, it's not only too generous, but it's inaccurate. And both the GBR and the guidelines of the Commission are. Why do I say that? Because our assumption is that there is a lack of a common understanding of what is an environmental tax. And this is due to the fact, as also Enrique was mentioning before, that we have different definition of environmental tax. So we may have a general definition that we will see in a few minutes, and then a specific definition that is dealt with in state aid law. And all these terms and definitions, as I was mentioning before, tend to lead to an inaccurate situation that cause uncertainty within the state aid framework. Okay. And then what is our research question? Well, we do think that there is a need of clarifying the use of key legal concepts related to state aid and, in general, tax measures in the energy sector. And only doing that, we may achieve legal certainty and we may improve efficiency with regard to tax benefits and reductions from environmental and energy taxes. But let's start from the analysis. So, as I was mentioning before, there is, or according to us, there is a general definition of environmental tax. How did we define or did we assess this general definition? Well, we started from the assumption that if we have a look at the ratio behind the introduction of environmental tax and what has been said by the European Court of Justice on that, we can conclude that environmental taxes are those taxes that encourage a behavioral change to promote environmentally friendly behavior and discourage environmental damage. And what is really important about this definition is that the design of the tax as such is fundamental. The structure of the tax as such is fundamental. So we cannot conclude that environmental taxes are those taxes that want to achieve an environmental objective as such, but we must conclude that environmental taxes are those taxes, the structure of which is directed at protecting the environment, taking into account either the tax base or the tax rate and so on. What about energy taxes then? Well, broadly speaking, energy taxes are considered as a subset of environmental tax. So we tend to agree, all of us, that energy taxes are included in the general category of environmental tax. Is that so? Well, not always. Why is that? Because energy taxes may not be able to achieve environmental protection sometimes. And the Energy Taxation Directive is one clear example of that. Because also the Commission achieved the conclusion that the Energy Taxation Directive is against climate change goals. However, this doesn't mean that they are bad as such, because they can achieve, as Enrique was explaining also before, other different goals. So they can achieve, they can lead to an improvement of the energy system, and they can ensure a competitive, sustainable, and secure energy system. So they may have other different goals. What does it mean? Well, if we agree with that, we achieve two preliminary conclusions. First of all, that environmental tax and energy tax cannot be considered two overlapping concepts. But some taxes may fit into both categories, because there are indeed energy taxes that, due to their structure, their specific structure, can be considered environmental tax, because they are directed at protecting the environment. Secondly, that energy goals may not always coincide with environmental goals. What about state aid regulation? Well, as was mentioned also before, we have both in the General Block Exemption Regulation and in the 2014 guidelines a specific definition of environmental tax, which is, as Enrique was also mentioning before, a very general definition, a very broad definition, which does not refer to energy taxes, but which is really a huge definition because it takes into account both taxes with a polluting tax base and with an environmental effect. And it's quite clear that there is no inevitable connection between taxing a polluting tax base and obtaining an environmental effect, as I was mentioning also before. This means that, yes, the definition within the state aid regulation takes into account all energy taxes harmonized by the Energy Taxation Directive, but this doesn't mean that they lead to a higher environment, that all of those taxes lead to a higher environmental protection. And what about the aid in the form of reduction in or exemption from environmental taxes? Well, as also Professor English was mentioning in the morning, they can be there only if they can at least indirectly contribute to a higher level of environmental protection. And what about energy goals? The ones that I was mentioning before. Do they count or they just do not? Moreover, in the general block exemption regulation, as was mentioned many times today, the only aid schemes in the form of tax reductions that is allowed is the one related to environmental taxes that fulfill the conditions of the energy taxation directive, which means that is accepted by the general block exemption regulation also those tax reductions or tax exemption that do not lead to a higher environmental protection. So it's already there, actually, in the regulation as such. Having said that, in our opinion, these lead to uncertainty, these lead to inaccuracy, and this is where I will give the floor to Marta that will explain us what we think is necessary to overcome this uncertainty. Thanks.
Thank you very much. I suggest we switch immediately to...
Yes, I will continue. As it was already mentioned by Professor Pitrone, in our view, there is a need to critically assess whether the legal reference to environmental taxes suits the purpose and the effectiveness of the special treatment of the energy taxation in the field of state aids. Assessing their effectiveness does matter because it has policy, design, and application implications. In our opinion, the current situation is not consistent. Harmonized energy tax incentives are qualified as environmental aids in the state aid context, breaking the objective of environmental and competition policies and being the rationale of the regulation in coherence with the rest of environmental regulation and also with the ECJ case law criteria. Looking for the proper approach, the first step in our analysis has been the study of the concept of environmental tax, check on the one hand against the one included in the general block exemption regulation and in the guidelines, and on the other hand against the notion of energy tax, coming to the conclusion that in the field of state aid, a specific legal configuration is used. Once the problem is identified, what can solve this inconsistency? In our mind, there are essentially three alternatives to the current regulation. First, to modify the current definition of environmental tax to accommodate it to the common concept of environmental tax, or to incorporate to the environmental tax concepts those energy taxes out of the scope of the energy taxation directive, but with similar characteristics. Second, to create a special regulation for energy taxes to refer to the same current energy taxes and their tax incentive instead of the reference to environmental taxes in place, because this system would allow placing greater emphasis to specific energy policy elements, but without implying a change in the objective scope of the incentive. A combination of both alternatives to regulate environmental protection measures and other policy-driven measures in a separate way, or to substitute environmental tax references for harmonized taxes can be also considered. In any case, pros and cons of the different alternatives should be taken into account. In favor of changing the current situation are the following arguments. To substitute environmental tax reference by energy harmonized taxes would solve the improper current use of environmental concept. And to use properly and in a coherent way the environmental concepts means, to our mind, effectiveness. Equal treatment to all environmental energy taxes according to the EU policies could be better addressed. To improve certainty and to reduce litigation is other important reason. To facilitate the creation of member state environmental taxes until a stronger tax harmonization is possible is another pro. To support the horizontal function of the polluter pays principle and other environmental principles. Or finally, to put the focus on the possibility and the need to use taxation as a tool for environmental policy and of the balancing exercise between distortions of competition and legitimate interests. On the other hand, the main inconvenience of our reform is the need to modify a consolidated regime linked to the Energy Taxation Directive. But there is only a need to change the Council-enabled regulation and the other related regulation. This is why our proposal is to refer directly to the concept of harmonized energy tax instead of the one of an environmental tax, and to split energy and environmental legal reference on the general block exemption regulation and the guidelines. Finally, beyond concepts, it would be desirable to review the current compatibility criteria towards more accurate, objective, and non-discriminatory ones. What is the best solution or the best option to guarantee an effective coherence between objective principles and legal instruments of different European Union policies may have little to do with substantive legal determinations. It is influenced by political choices and by the need to be adapted to new patterns. In any case, that is something we believe is demanded, and it is the correct use of legal concept in the EU regulation. Thank you very much for your attention.
Interesting proposals on our desk. Let's see what the comments are, and maybe I can ask you to really limit your comments to the proposals. I must admit that I have some difficulties imagine clearly how you envisage these things. It's formulated in rather abstract terms, and personally speaking, it would help me if I had some examples where your approach makes the difference from the present situation. But that may come later, and it may also stimulate you to provide some further examples in the future. Let's open the floor. Yes, please.
Thank you for the presentation. It was quite interesting, and this is a question for Professor Pitoni and
the microphone, please.
Professor Villar, because they were talking about the concept of environmental tax, and nowadays we have that to be an environmental tax, the Commission in the state aid domain, they take into account the tax base, the tax rate, or even in other domains, or the objective. But I was wondering whether if in the state aid context at the end we need some definition of environmental tax, we take into account also the real effects of the tax. I mean, the ex post effects of environmental tax, because I can call it environmental tax because the tax rate, the tax base, or the objective, but at the end I don't see any result in environmental grounds. So should be that call it also if the real objective is not achieved through the tax, should I call it that an environmental tax? Because for me that would be also a good grounds in order to determine if a state aid can be compatible or not with the market. Thank you.
Thank you for your question, Álvaro. I think the problem is not the definition of the environmental concept, only the definition of environmental tax concept on a state aid context, but I think it's better to forget this notion and to focus on the distinction between harmonized and non-harmonized taxes, and not connected environmental purpose or environmental effects, because in fact, member states don't have enough information to evaluate the effect of their own environmental taxes because of the legislative system on each state. This is why our best option, but we have to open our ideas to you all, is to forget the definition of environmental taxes as such, and to focus on the distinction between harmonized and non-harmonized taxes to better separate the insight in the general block exemption regulation and on the guidelines, but with so many details that we have not enough time to explain all our arguments. If you want to add something?
No, it's fine.
But I take it that you will take more time and that you will explore the ideas further and maybe submit it to the audience in writing or whatever. Yeah? Okay, let's see. Who else? Yes, please.
Yeah, this is just a comment, but I'm not familiar there with the general block exemption that you are discussing. But I was just missing there in your outline with regard to the definition of environment taxes, some reference to the official OECD and Eurostat definitions, because there are such official definitions, and I think actually the vocabulary there is that the definition addresses environmentally related taxes, and that also covers energy taxes. But I can follow that there are some differences as well, but I think OECD and Eurostat and some other institutions have actually made some joint work to establish such an official definition. So I think, as a comment to your final paper, you should somehow incorporate that in your line of argument.
Sure. Thanks a lot. Well, actually, one of I think the first part or the second part of the paper is also on that, because yeah, we are aware of the fact that there is another definition of environmental tax, which is unclear whether it can be considered the same, which is also something that creates other uncertainty, if you can put it like that. And another term that is used, as you were mentioning, is environmentally related tax, which may be something different, even though sometimes they are used more or less in the same way. But if you have a look at the wording of both these definitions, they may reveal differences. And this is also why we do think that there is a lack of a common understanding of what is an environmental tax. But this is an important point, and of course we didn't have time to mention also that, but we took that into account, absolutely. Thanks.
Thank you. I heard before a short debate regarding the general block exemption regulation. Could be a sort of soft law or a proper law, but seems to me that is really a regulation. It is an EU regulation, so it's possible consider this GBR as a real binding regulation. The question is, first of all, for Enrique Fonseca.
Thank you. Well, the question, the nomen juris, I don't know if it is important. To me, it is important. I'm afraid to use this poor argument among professors, but first of all, the block extension regulation is published under the name non-legislative acts in the official Gazette of the European Union. But in addition to that, to me it's important because I think that the evaluation of the, for instance, of the discretionality is not the same if we are talking about general regulation, about law, or if we are talking about executive acts, no matter if they affect to a generality, if it affects a lot of subjects of law or not. In addition to that, to me it's important because also the general block exemption regulation is a consequence of the enabling regulation of the Council. And the authorization is in order to develop a regulation in relation with measures to protect the environment. To protect the environment is, or measures related to the environment is a concrete authorization. And in my opinion, when there is a equalization between harmonized energy taxes and environmental taxes, I'm not sure that this discretionality allows the Commission to go as far as that. I'm taking into consideration that the 2003 directive includes this equalization because the preamble of the directive is equalizing environmental taxes with harmonized taxes and with measures needed in order to pass the law. According to this, they consider that these incentives are environmental-driven incentives. But at the end of the day, are different scenarios. One of them is the task one, and the other is the state aid regulation and the application of a horizontal principle, because at the end of the day, the discussion here is that when we use the word environmental, we are referring to a policy of the Union and to a policy that is based in a certain principles, mainly the polluter pays principle. And
I have a notice here telling me that time is over. So if you can be really brief, I must just note that I don't really agree with your interpretation of the block exemption. It is law, however it is published. And the Court of Justice has always recognized directives and regulations of the Commission as being law. Anyway.
Even if it's not active act on the German Court.
Yeah, yeah, that's just the wrong categorization in the official journal. Okay, one short question, please. No, sorry. It was the gentleman in the back. Sorry.
Professor English.
Well, okay, one short question. I have actually two, but I will ask just one. What I don't understand, so just didn't get it. When you say a tax that has as its tax base a polluting tax base, so which is dependent on the extent to which some polluting form of energy consumption takes place, why would that not achieve a higher level of environmental protection? I mean, this tax clearly sends a price signal, and if there is any kind of price elasticity of demand, which usually there is in the energy sector, this should lead to a reduction of the consumption of this polluting energy source. So I don't understand. Why would you say that there is no effect on the environment?
Yes, I will be brief. Maybe we can discuss that later on.
Coffee
yes.
is a good place to discuss these matters.
Well, it's the Commission as such that defines many energy taxes in the directive not compliant with the climate change goal, because the tax base as such, even though it's considered as polluting tax base, is not enough to have an effective environmental goal, let's say. So this is the main point, but we can discuss it later if you want. Yes.
Okay, this brings us to the end of the session. I have to apologize for not starting with a word of thank you to the organizers for this wonderful occasion. It's always a great pleasure to be here, and it will be even more a pleasure to continue to contribute with you. Thank you all very much for this session. The session is over and coffee is ready.